Welcome to the Productpreneur Podcast. I'm your host, Nicole Delarzak, product development and marketing coach and mom of three. Learn from and get inspired by women entrepreneurs killing it in the product space. Each episode, we will share the latest trends, proven strategies, and inside secrets of the product world, all designed to give you greater confidence to create your own success through a product venture. Let's do this. Welcome to the Productpreneur Podcast. I'm thrilled to introduce today's guest. You are in for a treat, and this is the one you need to bookmark and save and come back to over and over again. But first, let me share a listener review. This is from Ali Brett. Thanks, Nicole, for having me on your podcast. Product launching is a hard but fun journey, and I love sharing my story with your audience. I appreciate how comfortable I was chatting with you and love both your support and positive energy. I hope that this episode contributes to the bigger picture and helps other product launches in their own journey. I cannot wait to listen to your next episode. Thank you so much, Ali Brett, for being on the podcast. You are amazing, and so is your invention. If you haven't listened to this one, it was episode 26 about her invention, Clasp Magic. Now, if you're listening to these episodes and you haven't done so already, please take a minute to give a 5-star review on iTunes, and I would be so grateful, and you'll help others find the show. Also, you may have heard that I'm offering a free one-on-one strategy session at this time. This is perfect for you if you'd like help with scaling your product business or if you're thinking of launching a product. We'll talk about your business or idea and you'll walk away with action items, and I'll let you know what working with me is like if it's a fit. You can go to NicoleDelarzak.com and book it there or click on the link in the show notes. All right, back to the show. Have you wondered if it's time to register your trademarks, but you're just not sure when is the right time and if it's worth the investment? Do you know if your brand is even a candidate to be protected? In this episode, we speak with Cynthia Mason, lawyer and founder of Markably.ca, a company that makes brand protection accessible to entrepreneurs, as well as founder of MasonPC, a boutique law firm. Cynthia is a Canadian lawyer and trademark agent with a passion for helping businesses arm themselves with the tools necessary to protect their businesses from copycats. Over the span of her near 20-year legal career, she's worked with numerous Fortune 500 companies to protect their names, logos, and taglines from theft and misuse. Cynthia is also a legal innovator and has developed an online platform for registering and monitoring trademarks, making professional brand protection accessible for entrepreneurs and small businesses. You'll learn so much about trademarks, including why a trademark registration is important, when should you file for one and where? What are the best types of names to file? How to find out if your name is taken? DIY applications versus getting legal help? And so much more. I hope you enjoy the show. Welcome, Cynthia. I'm so happy to have you here. This is going to be eye-opening because I know that I have so many questions about trademarks and legal, and then I know my clients and our listeners do have questions as well. So this is going to be super informative. Thanks for coming.
Thanks for having me. I'm glad to hear that people are asking questions because really that is where it starts. You have to get the information and then you process it and figure out how it applies to your business, and that's usually when action happens. So I'm here. I'm happy to answer any questions. Yeah, let's talk about protecting trademarks.
Yes, absolutely. Now, we just started speaking about my own trademarks, and that's when it dawned on me, whoa, we definitely need to have you on the podcast because it's so important. So if you could tell us a little bit about your background and why you started working with entrepreneurs in the legal space, that would be amazing.
Well, I am a Canadian lawyer. I've been a lawyer for just over 18 years, and I am a registered trademark agent. My entire legal career has been focused on trademark law and helping businesses protect their brands. I started my career at a large Toronto law firm, worked there for about a decade, and then I started to move east. I'm from the East Coast, and I kind of wanted to make my way back there, but I got stopped in Ottawa because at the time when I was moving, the Halifax law firms didn't really have space for a dedicated trademark lawyer. I don't think they had the client base, and so there really weren't any jobs on the East Coast, so I stopped in Ottawa where I have other family, and I'm kind of just here. I'm staying, and I have continued to work with many of the same clients that I started working with 18 years ago are still with me. Picked up a few more along the way. I work for large businesses. I work for consumer product businesses. I work for service companies. I work for a whole handful of foreign law firms who have their own clients who protect trademarks here in Canada. I have a lot of experience advising companies on how to protect their trademarks under the Canadian legal system. And 6 years ago, I opened up my own law practice. The law firm where I was working suddenly went out of business while I was on maternity leave. So I took all of 30 seconds, made the decision to go out on my own and kind of split my time between raising my family and continuing to help my clients protect their trademarks. And so it was really an opportunity to start working with businesses who really need the advice and the education and easier, more accessible tools for protecting their trademarks. And really that's kind of where my evolution into really working with entrepreneurs and helping them protect their trademarks and advising them on, taking the experience that I've learned from the big consumer brands and distilling it down into a formula that is easy to follow so that they can also protect their brands to the same level, but under a less expensive and kind of less rigorous way.
That's amazing. So you mostly work with entrepreneurs?
No, I still split. I still have some pretty big clients and companies that I work for. But over the last couple of years, I have developed an online tool for specifically for entrepreneurs to help them kind of DIY their way through a trademark registration. And so my business is kind of split. It's split between entrepreneurs and small businesses and startups and the established large businesses as well.
Yeah, it sounds a bit similar to what I do because I took sort of my corporate experience and wanted to apply it to entrepreneurs, but a more cost effective way, simplified way so that it's accessible to them. Because when you're just starting out, it's very difficult when you have all these costs coming at you. So yeah, it's really important to have the help that you offer. And I've heard your name in so many circles of entrepreneurs, so it's amazing. I wonder if you could just start by telling us about the different kinds of trademarks. What are the levels of trademark registration? For example, I've seen TM and R and everything, and I just want to make sure that everybody's aware of, hey, what is a trademark and what are the possibilities there?
Oh, these are some great questions. Well, a trademark is really anything that you are using to basically distinguish your products or your services, whatever you're selling, from those of your competitors and everyone else. And so the most common types of trademarks really are names, their logos, and sometimes it's a tagline too. But I mean, anything can really be a trademark. You can trademark the way something is packaged or the way the product looks itself. You can trademark jingles and smells and tastes. Like you can trademark anything now. But the majority of businesses have at least a name and a logo. And those are basically what we most associate with trademark rights. There really are when you have the understanding of what your trademarks are, there really are two different, I would say two different statuses as in the law. You can have a registered trademark or an unregistered trademark. They're both trademarks. I often, have conversations with entrepreneurs who they're starting to get some traction in their business and they say, "Well, I really need to trademark something." And the reality is they've trademarked something as soon as they adopted the mark and started selling a product or a service. They've trademarked it. Now, what the next step that they're looking to take is to register it. And so, under the Canadian legal system and the American one as well, both unregistered trademarks and registered trademarks are enforceable against infringers. So, without a trademark registration, you can still enforce your trademark rights. It's just a lot more difficult because there are certain things you have to prove. So, the TM symbol is often used to label an unregistered trademark. Once it's registered, you change that little TM to an R and a circle, and that lets the world know that that's a registered trademark.
That's really interesting. So, if you don't register something, but say you're the first person to use it in your country or in the world.
Well, it's a little bit more difficult now where everything is online, but trademark rights are country specific. And so if you are the first to use a trademark in Canada, you own it.
Ah, okay. So, as long as you can defend that you were the first to use it.
But when it comes to enforcing that unregistered trademark that you were using against other people, you will have to prove that you were the first to use it. And so that's why it's one of the reasons. I mean, there are so many reasons why you would want to make that a registered trademark, but really under the Canadian legal system, the first to use a trademark is the one who is the correct owner and the true owner of it.
Okay, actually, that brings me to my next question. Why is it important for business owners to register their trademarks?
Well, really, it comes down to cost because there is more that you have to prove in order to enforce your unregistered trademark rights against somebody who's copying you. It will cost you more to enforce it. And so when you take the steps and you register it as a trademark, I mean, we can talk about the benefits of registering a trademark and there really are many, but it all comes down to the cost of enforcement is a lot less when it's a registered trademark versus an unregistered trademark.
So, what happens actually if somebody uses your trademark, whether it's registered or unregistered? What do? You do a cease and desist, or
Yeah, well, at first, I mean, I recommend that clients kind of answer a couple of preliminary questions. It's going to take a little bit of investigation. I mean, the first thing that you want to take a look at if you see somebody else using your trademark or something that's very similar to your trademark is you kind of have to ask yourself, well, are they in a are they competing with me or are they in a related field? Would the average purchaser in Canada see their mark and think that the products and services that they're selling are somehow related to mine? And so that's kind of the very basic premise behind making a legal argument of confusion between trademarks is whether the use of two marks is likely to lead people to believe that those products or those services come from the same company. So, if you're answering yes to that question, then the next question you have to ask yourself and you have to really investigate is, well, who was using that name first? Because the last thing you want to be doing is, sending a cease and desist letter alleging a risk of confusion or a likelihood of confusion if they were in fact using the name first, because that puts you in the wrong. So, those are basically the two kind of, base questions that you would want to ask is whether there is a likelihood that people are going to think we're somehow connected and who was using it first. And if you were the first user, there is a likelihood of confusion, then I would say yes, your next step is going to be you need to notify that other party of your rights and that they're going to cause confusion and they need to stop. And that is the first step. I find oftentimes entrepreneurs are hesitant to take that first step because they're seeing the dollar signs of what it's going to cost them in order to enforce their legal rights. But in my experience, 95% of the time, things get resolved with a couple of communications, like a cease and desist letter, an exchange back, and a resolution as to when they're going to stop and kind of transition out of a name. So it doesn't take thousands and thousands of dollars to enforce your rights, but you do have to take that first step. If you just concede defeat right at the very beginning, then you've already lost.
right, right. Yeah, no, that's good to hear that in a couple of letters that companies usually will back off, which is great. So when should product business owners look to register their trademarks? Because, usually they're under a tight budget and they don't even know if their product business is going to fly. So a lot of people just wait to see what's going to happen before they actually register it, and so they want to sort of see some sales. When would you say it's ideal for them to register? And maybe when is it kind of more realistic? Because I think I know what the ideal would be.
Yeah. Well, in my experience, most businesses, product based or service based businesses, wait between after they're started selling between 1 and 3 years after their first sales before they take steps to register their trademarks. I think they do this for a variety of reasons. The first one, of course, is budget. There is a perception that registering your trademarks is an expensive proposition. It's actually not, but they also kind of wait to see if they have something of value that's worth protecting. And so, between 1 and 3 years is when you start to get more sales, you get a little bit of traction, you get a little bit more money in your bank account, and you start having people telling you, you have a really great product, you have a great name, you should look at trademarking that. And so that's when businesses tend to take the steps to register their trademarks. Now, ideally, they're doing it way earlier. And I can tell you the big businesses do it way earlier. Big consumer brands, as you know, they take the steps, they clear their trademarks, like globally, if it's a global brand, they will make sure that it's available in all the markets that they want to use it in. And then they will file a trademark application. And here's the one reason why product based businesses would want to file a trademark application before they start using a mark, before they start selling anything, is because a trademark registration or a trademark application will reserve your right to use a name in the future. So, one of the things that a lot of people don't really understand about trademark legal rights is that you only have legal rights when you're selling something in connection with a name. So, if you are developing a product, you're obviously not selling it right away. There is a development time associated with getting your product to market. And so I find with entrepreneurs tend to think up the name before they think up anything else. Like there is an emotional attachment to the name, and they have it in their head that they're going to use this in connection with the sale of whatever they're making. And so then they start developing that product, but they've got the name in their head and they're emotionally invested in it, and they're taking no steps to protect it other than, well, they've got a domain name, they've got a couple of domain names, they got the social pages, they've got all of this stuff. They're mocking up some packaging and some labels. They got, a landing page, but they're not taking really any steps to own the name, and they don't actually have legal rights in that name until they start selling something. And so just by filing a trademark application, that is the date that your legal rights can start. So there is so many benefits to filing an application, but for product sellers, that is the big one. It's to reserve the right to use a name in the future. And in Canada, you could probably string that along for 5 years before you start selling.
Yeah, well, I remember as in consumer products, we would brainstorm a whole bunch of names. Maybe it's like 10, I don't know. Bring that to the lawyer, and then they do the searches, and then maybe one of those would work. So there's often something wrong with different names. And then if it doesn't matter what it was, we would reserve, if it was a couple of names, we'd reserve that until further notice to see, whether or not we launched, we didn't know, but just to reserve it, put a stake in the ground. So yeah, it's super important. And a lot of people do think that just by getting the website that it is fine, but it's not.
It's not. All you have is a website. All you have is a URL. You have nothing other than you're stopping other people from getting that URL. And sometimes, that is something in itself. But in terms of legally owning a name, you don't until it's on a product and the product is physically being sold and transferred to purchasers. And the way to kind of jumpstart those legal rights is to file your trademark application. One of the other reasons you would want to do that, to file your trademark application early, is because it takes a ridiculously long time to get a trademark registration right now. In Canada, you're looking at a 2.5 to 3 year wait from filing your trademark application before you have full rights of registration. So, up into the point where, this is another misconception that a lot of people have, is that filing the application is actually registering your trademark, which isn't true. It's the first step in the process. You have to file the application. The application gets examined by an examiner with the Canadian Intellectual Property Office. And then if they're going to examine it to make sure that that trademark complies with Canadian laws and that you've described your products and services in compliance with their regulations. And if all of those requirements are met, they will approve your application. It's published for third-party opposition. So if there's anybody out there who thinks they have better rights than you to that name, then they can oppose. And if there's no oppositions filed, then the mark will register. And currently in Canada, that process is taking about 2.5 to 3 years. So until you've got the certificate of registration and you can put the R on your trademark symbol, you have still an unregistered trademark. And so, I think now is probably another great time to talk about one of the main benefits of a trademark registration is it gives you fast and easy proof that you are the owner of that name. And that fast and easy proof is basically the accepted evidence now for online takedown actions. So these are actions that brand owners can take on all of the different e-commerce platforms, Amazon, Etsy, well.ca. They have venues or they have complaint procedures in place for brand owners who see their mark being infringed by a third party to contact the platform. You don't even need to send a cease and desist letter to the user. You can just contact the platform and get the platform to take the infringing content down. And by infringing content, I'm talking about an infringing trademark. But in order for them to do that, they want proof that you are the owner, and your trademark registration is that proof. And so if you know as a product seller that you're not going to get a registration, that you're going to be in the unregistered trademark zone for 2.5 to 3 years, wow, you really need to file your trademark application early in order to kind of speed up when your full rights of registration are going to exist.
Well, that's good to hear that the platforms will take it down and that really all you need to do is provide proof.
Great option for, I mean, I have a client, they're in the entertainment industry, and they have some brands that are very popular right now, like it's in prominent pop culture usage. And so, but I mean, this client also has a merchandise program, and so these products, they have a ton of different sellers out there on Etsy and a whole slew of other e-commerce platforms that feature their brands, and those products are competing with the official merchandise program. And so, we've got the trademark registrations, we've got monitoring in place, and they are aggressively pursuing the people who are using their brands, and they don't need to even know where those users are. All they need to do is just file their easy complaint with like Etsy, and demand that it's taken down. It's taken down within a couple of weeks, and it really is cutting off the access to, sales that the infringers have. And so trademark registrations are incredibly valuable for that.
So, say, within those 2.5 to 3 years, you might be using a mark that doesn't end up getting registered. So, should you try to get, a couple of them registered at once just to, just in case? Or is the sort of preliminary search that you do enough to be sort of confident that you've got a good mark?
Well, it's funny, like, and you can clearly tell you come from a big brand background, a big corporate background. That was the approach, years ago, is that, the big consumer brands would come up with 5 or 6 different options for a particular product name, and then they would apply to register them all and see which ones could go through. Given the timing and the cost now, like, they don't tend to do that. What they are investing in is a more comprehensive search before they decide on a name. And so, given that it's going to take you 2 years, well, I mean, in Canada, the real delay on a trademark registration is in examination. It's currently a 2-year wait to get a trademark application examined. So, if you know before you file that it's going to be 2 years before you're going to hear from the trademarks office on whether they think your mark is registrable, you're much better off to invest in a comprehensive search beforehand and determine on your own whether that mark is going to be registrable before you invest in not only the trademark application, but before you invest in marketing and developing that brand. So I would recommend that, the sequence of events that you take as an entrepreneur is you decide your name. If you're emotionally attached to it, do the searches, make sure it's available. And once you've satisfied yourself that the mark is available, file your trademark application to reserve it, and then you start developing your product and your marketing plans, and then launch, and knowing that ultimately the chances are much higher and the risk is a lot lower that you're not going to get a registration out of that you in fact will be able to register that name in the future.
Okay, okay. And actually going back to the trademark search. So is it fine to just go on Canadian trademark database or US trademark database or whatever and search for that name? Or do you need the help of a lawyer? Because I do remember it's sometimes a bit tricky. Like you don't know if somebody has rights in a different classification and so on. And so what would you recommend there?
I recommend, I mean, in terms of countries, for sure, I mean, Canadian businesses, almost 100% of cases, a lot of Canadian businesses have plans to ultimately sell in the United States. So I certainly would not recommend that you just search Canada and think that you're fine, because the United States is a much bigger market. And so they are integral to your future profit plans. You want to make sure that your proposed mark is available here and it's available there. So you want to do the searches in both countries. In terms of what you are going to search, my recommendation for entrepreneurs, because it is a budgetary constraint, is that you do some preliminary searches yourself. There are certain searches you can do. Oftentimes, if a mark is not available, in my experience, it's usually something pretty obvious that's going to block it, that you can discover either by way of a Google search or by searching the exact name or the beginning component, the most dominant element of your name. Search it on the Canadian and the United States Trademarks Register. They are both publicly available. And if nothing comes up at that point, you haven't found anything by Google searching, in the first couple pages of search results, search social media to see if anything is out there. Those tend to be pretty good indicators of whether, if you're going to find something obvious that's jumping out and going to block your use of a name, you'll find them in those searches. So once you've done some preliminary searches yourself, then engage a professional to do it, because we do a more fulsome search. And the way that we kind of search for our clients, we search in Canada and the United States. We search the trademarks registers in both countries, and we look at whether there are identical marks, but also marks that are similar in appearance, in sounds, and in suggested ideas. And if there are any marks that fall in that kind of category, then we look at the associated products and services to say, well, are they competing with our clients' products, or are they related to? So both could lead to a risk of confusion. Clearly, like identical products or identical services are, it's fairly intuitive what that means, but like something that's related, examples would be if there is a company using your mark and they're selling razors, but you're selling, shaving lotion, like those aren't competing products, they're actually complementary, and so they're related. And so the average person who sees, a similar or the same mark on both of those products would think, well, they're coming from the same company. They've branched into this other field. Similarly, like, oftentimes when we have clients who are retailers and they sell a particular type of product, maybe like a toy retailer or, a cosmetics retailer. And if there are those products, toys or cosmetics or, the potential products that they could be selling under the same name that they're planning to use, then those are not competing products, but they're and services, but they're certainly related. And so that type of analysis goes into whether, something on the register is confusing. Then we kind of take that same analysis and we look at marks that are unregistered. So, marks that you just find in use on e commerce platforms or just on the internet generally, in social media, in business names. We do some investigations into similar business names, domain names. The typical places where you would find unregistered trademarks tend to be on e-commerce platforms when it comes to products and on social media. And so we do the same analysis for every potentially similar name that comes up. We look at whether they are in a similar field or, are the same competing products or services or are related. And we, make an assessment based on what we find in our searches on whether a name looks like it's available. And if it is, we recommend that you file a trademark application as quickly as possible to reserve your right to use that name in the future.
Okay, wow, that's great. So that's very thorough. Like you need to do a lot of research yourself to see what's being used and if it's being used out there. And what if it's being used actually in a different sort of classification? I know there's different classifications. Like one is maybe it's like hardware or there's software or whatever. Skincare, I don't know. Like there's different classifications. So say if it's being used in a totally different classification, are you still okay or should you kind of be wary?
Well, I mean, the classification is actually, they're called classes, and there's 45 of them in the world. So all products and services fall into one of the 45 different classes. And under Canadian law, the test for confusion is not limited to there are marks in your proposed class. So, for example, if you are selling clothing, you are in class 25. That is your class, but there may be other classes that are related to class 25. So clothing is in class 25, but bags like purses, they're in class 18. The class system is fairly new in Canada, so we're kind of still getting up to speed with like remembering the class numbers. But so if somebody sees a mark on clothing and then they see the same mark on a purse, there is a possibility that they're going to think, oh, they're coming from the same company, even though they're in different classes. So I don't recommend that people get too hung up on the legal classifications for products and services. Instead, they have to kind of look at it from a common sense perspective on whether, the average person is going to think that these products or these services come from the same company from a logical perspective, whether it's likely.
Oh, right. Wow, that's very thorough. And that's why a lot of people just make up names because it's so hard to find a name that isn't used.
Well, it's true. And from a legal perspective, completely coined, made up words are way better trademarks. I mean, marketing people don't tend to like them because they feel like they're starting from a disadvantage, that they have to explain to consumers what the mark really means. And, oftentimes I find marketing people want to have a trademark that tells the public what they're selling. Lawyers hate that because that's making your mark close to generic. It's descriptive. It's not as strong of an indicator of source. And so over time, the coined words, the made up words, they become better known for what they're the associated products and services than the ones that are somewhat descriptive, because descriptive marks are generally not considered to have strong legal rights. And so courts and the trademarks office will allow more similar marks to kind of coexist with these descriptive words versus a completely coined and invented word where they'll give it a wide scope of trademark rights.
Right. Actually, that's my next question. So, what is just not trademarkable?
There's a couple of different things that you would want to avoid as a trademark. Descriptive words, obviously, descriptive and generic words, just stay the heck away from them. They're not great marks, and it's difficult to stop other people in your industry from using them. Also, sometimes, people have a hard time thinking of a name, so they're like, okay, well, what's the foreign language word for this? And so they'll adopt a foreign language word for their product as a trademark, and actually, that's not protectable either. Examiners are very good at Googling trademarks to find out what it actually means. And if it's a foreign language word, you actually have to give the translation of it. And if it is the name of your product or your service, you're not going to be able to protect that. Personal names, my name is not really registrable as a trademark for legal services because I shouldn't be able to stop somebody else with the exact same name. So personal names are terrible trademarks. Geographic words and names, also not great trademarks, because there is a provision of the law that says you can't register a trademark that is a geographic word if your products come from or are known to come from that area. And if they don't come from that area, then you're misleading people. So geographic words, also not great trademarks and very difficult to protect. And then the other big category of marks that are just not protectable are marks that are confusing with a previously registered or in use trademark. So that's why you would want to do your searches beforehand, because if there is something confusing on the register, you're not going to get a registration. If there's something confusing that's in use, you are running the risk that you're going to be getting a cease and desist letter from that trademark owner. It doesn't only leave coined words, completely arbitrary words. I mean, like Apple, that's like it's a common English word, but it's become a very well-known trademark for consumer electronics. So coined words are the kind of the gold standard. Arbitrary words are not far behind.
Sometimes you think of a common, like you think it's not a common name, but then the lawyer tells you, no, it's a common name and you can't use it. And then you got to find something else. But you're right. Marketers want to use descriptive names because it makes our job easier. We don't have to describe exactly what we're selling, it's in the name. But right, if you think of the strong brands, they don't really have those descriptive names.
I mean, some of them do, some of them don't. I mean, if you're an entrepreneur and a startup, I would say you're better off to pick a completely arbitrary coined word or arbitrary word and then describe to consumers what you're doing by way of a tagline. You can protect taglines as well, but you can also just use them from a marketing perspective to let people know what it is you're actually selling.
And if someone's just starting out and they want to register or search for a name, is it something that they can do on their own in terms of registering, or do you recommend seeing a lawyer? Like, is there a DIY kind of version?
There's basically three different kind of routes that you could take to register a trademark. As a Canadian and a trademark owner, you can apply to register your own trademarks. You create an account with the Canadian Intellectual Property Office and you can DIY your trademark application on their platform. It's not a super user friendly. You kind of need to know a little bit about what needs to go into each field in order to properly complete it, but you can easily do it, with a little bit of research, you can do it yourself. And that cost is just going to be the government filing fees. So, we had talked about the classes. When it comes to a trademark application, the government filing fee for that is based on the number of classes that that your products, your services are going to fall into. And so the cost is $330 for the first class and $100 for every additional class. So, it can kind of add up over, if you have a wide range of products that you're planning to sell, then, you could easily be several $100s in a government filing fee.
And that's in Canada.
That's in Canada. In the United States, the cost is just $275 for every class. There's no graded system. So it gets expensive very fast in the United States. $275. And yeah, it's expensive. It can be expensive there. The next kind of level up from that is there, I offer an online service that guides entrepreneurs through the DIY application process. So I have created an online platform that asks the questions that they're in the language that they would more likely understand than the way the trademarks office is asking these questions. So my online platform takes guides applicants, entrepreneurs through the application fields, explaining how to answer each of the questions. And particularly when it comes to classifying your products and services, you don't have to do that for yourself. On my platform, you just select the products or the services that you want to include in your trademark application, and then I classify it for you, or my platform classifies it for you and calculates the government fees so that you know that at the time of filing what it's going to cost you. And you can add on kind of like the next level of registration is you just hire a professional to do it for you. I mean, obviously that is the more expensive option, but it also kind of out of that, you get a professional to work with you in terms of reviewing your marketing plans and your business plans, taking a look at what you're currently doing, asking and giving you prompts to determine what your plans are for the next 5 years, and then creating the application for you and kind of including everything in terms that the trademarks office is going to accept. So while you can't just, you obviously want to claim the products and services that you plan to sell, they have to be described in a way that the trademarks office is going to accept and understand. And it doesn't always jive with, the way average people speak. And so there is kind of like a translation component to preparing the claims of a trademark application, and it's to make sure that the products and services are properly classified, but also described in compliance with trademark rules. And so when you hire somebody to do it for you, that's included. And then the other part of hiring someone to do it for you is they will deal with the examiner if there's any objections. They will monitor the application through the approval and the opposition and then the final registration stage, and stay on the register as kind of your representative in terms of that mark for the life of the registration, which can be indefinite, but it starts out with the first 10-year term. So trademark registrations, once you get them, they're good for 10 years, and then you have to renew them if you're continuing to use the mark.
Wow, this is fascinating. So actually, it could save you money to work with a lawyer because say you apply and you actually don't know what you're doing. So you spend all this money and you apply for a mark that you think is available, but it's not even available. And so you've just wasted a bunch of money.
You wasted a bunch of money and 2 years of your life.
Right. Yeah.
Yeah.
Right. And it's risky. So,
Working with a professional for sure will save you time, because if you file the application and it's not in compliance with, if not, things aren't classified properly, they're not described properly, there's confusing things on the trademarks register, you have to deal with that. And you get an objection, you get the opportunity to respond to any objections, but it delays your application beyond the usual or the minimum 2.5 year wait. You're going to be looking at 3.5, 4, 5 years to get your trademark registration, and there's no guarantee that what you've applied for you're actually going to get. So yeah, if you work with a professional, there is a lot of benefits and advantages to having somebody, make sure that you're not going to be running afoul of the technicality requirements, and doing that search for you to make sure that there's nothing on the register that should be raised as an obstacle, and then kind of guiding you and acting on your behalf through the whole process. It makes it faster, and in the long run could make it a lot less expensive overall, even though you have to pay the upfront fee for that.
you just convinced me. I remember this is kind of an example, not legal related, but once I tried to do my own taxes because I thought, oh, it's simple. I didn't really have much to do this year. And so I did it myself, and what a headache. I ended up paying penalties, and because I made these mistakes that I didn't even know about. I thought it was super simple. And so I've always used an accountant since. So it's one of those things. You think you can do it, but you just don't know the ins and outs.
Well, there is that, and I mean, as entrepreneurs, like, and I mean, I am an entrepreneur, so I get this. And like, trust me, I'm the idiot that did bookkeeping myself for like a couple of years when I should not have been doing that. and and you spend a ton of time on this stuff that is not your zone of genius. It's
Right.
not even your zone of mediocrity, really.
Yeah.
And you could be doing something better and something more productive with your time and something that will have a whole lot more impact on your business than
Oh, for
saving
sure.
yourself not even a couple $1,000s, like working with a professional in order to register a trademark. If you're in one or two classes, you're less than $2,000, including government fees. Like it's not a lot of money, really. For the benefits and the things that you get out of a trademark registration, it is really a legal tool that you'll get a lot of value for the cost.
This has been amazing. Okay, thank you so much. I've learned a ton from this conversation, and I know the audience will be so grateful for this information. So, if they would like to hear more about your services, where can they find you?
Well, I'm everywhere. I've got actually 2 websites. So like I said, I have an online platform that helps entrepreneurs DIY their trademark registrations. There is an option in that platform to add on legal services or legal support throughout the registration process. You can find that at Markably.ca. If you want to just skip the DIY component altogether and just contact me, I'm happy to do it for you completely. And in that case, you want to contact me at MasonPC.com. You can always find me on LinkedIn. I'm active on LinkedIn pretty much all day, every day. So I'm there. Connect with me on LinkedIn. I'm happy to connect there. We have a ton of content that we post on LinkedIn, specifically to educate entrepreneurs about protecting their trademarks, and all of the different things that you can be doing as a brand owner to make sure that your marks are protected from theft and misuse. And yeah, so Markably.ca, MasonPC.com, or on LinkedIn. I'm also on Facebook and Instagram, but I'm not that great with those platforms. So it's probably better to look me up on LinkedIn.
Okay, awesome. Well, thank you so much for your time. I'm so grateful for you coming on, and I'm sure everyone got so much from this. Thank you so much.
Oh, I hope so. Thank you for having me.
Thank you for listening to the Productpreneur Podcast. If you loved this episode, we'd be so grateful if you could take a sec to subscribe, share it, and review it on Apple Podcasts. Your review will help more women build their own dream product business. By the way, if you have any feedback, comments, or questions, email me at info@nicoledelarzac.com. Until next time, keep dreaming up those product ideas.